pleased to introduce our next speaker, Barrister Ogaga Ediru, who will deliver a lecture on medico-legal issues in bloodless medicine and surgery. Ogaga Ediru is a legal practitioner, health law scholar, and researcher. He holds an LL.M degree, which is master's degree in law, from Benue State University, Makurdi, Nigeria, and obtained his LL.B degree, bachelor's degree, from the University of Benin, Benin City, Nigeria. He's a member of the Nigerian Bar Association with over 7 years' experience as a legal practitioner in private legal practice. He was previously a lecturer with Nasarawa State Polytechnic, Lafia, for a period of 3 years, where he taught selected law courses. As a legal scholar and researcher, he's been actively involved in research into various aspects of health law and ethics. His research interests focus on negligence, consent, mental health law, and recently on issues of consent in the medical treatment of children. I'm a pediatric hematologist, so I appreciate that. He is an author of scholarly articles in peer-reviewed journals, and notable among his works is his article entitled "The Emergence of Bloodless Medicine and Surgery in the Treatment of Patients, Medical Legal Issues Arising Therefrom."
Thank you very much for that introduction, Louis. Really appreciate it. Good day to everyone. It's happy to be among medical professionals. I feel blessed. I really feel blessed. Now, to get the ball rolling, just give me a minute. Yes, the theme for discussion for my presentation is medical legal issues in bloodless medicine and surgery. I have no disclosures. I took the time out to make an outline so that everyone will follow through. I'll just leave it up for some time. Let's say a few seconds, and then okay. Now, bloodless medicine and surgery, it's an alternate form of treatment that seeks to provide medical treatment for patients without the use of allergenic blood and blood products. Now, like every other form of treatment, bloodless medicine and surgery also has legal implications. It also has ethical duties as well as professional liabilities. Well, this presentation examines the medical legal issues arising from the use of bloodless medicine and surgery treatment, particularly issues of liability in the use of bloodless medicine and surgery, the rights of adult patients to consent to or refuse treatment with allergenic blood, and the issue of informed consent in the treatment of incapacitated patients like minors, mentally incompetent patients, and patients in emergency situations. Well, the objectives, pretty much from the introduction, we're examining the issue of liability, and we are going to explain the rights of competent adults to refuse treatment, and then identify the challenges in the use of bloodless medicine and surgery in the treatment of patients such as minors, mentally challenged patients, and patients in emergency situations. Now, we want to look at the issue of liability in the use of bloodless medicine and surgery as a form of treatment. A deviation, but before I start, I just want to bring to our notice that I made use of legal principles, and then I backed them up with statutory, mostly judicial authorities. And these authorities, judicial authorities, are taken from cases, legal cases from Nigeria and also from the UK. As much as possible, I tried to incorporate conventions that have a wider coverage. Yes, like the United Nations conventions, so that everybody will be able to understand. Now, a deviation from ordinary professional practice in medicine is not necessarily an evidence of negligence. According to the justice in Hunter and Hanley, if that were to be so, it will hinder progress in medical treatment if the law were to hold otherwise. And so this therefore means that the choice of bloodless medicine and surgery as an alternative to the normal practice of blood transfusion is in itself not necessarily evidence of negligence. Now, in some cases, they've laid down some principles or tests that such alternative treatment must pass. Now, that alternative treatment or a departure from the normal practice is not negligence as long as the departure is accepted as proper by a responsible body of medical men skilled in that particular act. This means once there's a professional man, or let's say a school of thought, and medical professionals agreeing to such treatments, then the use of such treatments is not by itself negligent. The second test was laid down in Bolito and City and Hackney Health Authority, where the court held that the departure from common practice must be logical, and the court must have ensured that the experts had directed their minds to the question of comparative risks and benefits and reached a defensible conclusion on the choice of treatment. However, this doesn't mean that those who undertake bloodless medicine and surgery treatments are devoid of liabilities. And so doctors who undertake bloodless treatments would be liable in negligence if such treatments are devoid of reasonable care and skill. The previous speaker talked about consent, and then she talked about consent from the ethical point of view. But let's look at it from the legal perspective. Now, consent must be sought before proceeding with bloodless medicine and surgery treatments. Now, failure to obtain consent opens up a health care provider to battery claims. And as such, a patient can sue a doctor if the doctor does not validly obtain his consent, first had and obtained before undertaking such treatment. Now, a doctor is also under a duty to take reasonable care to ensure that the patient is aware of any material risk involved in any recommended treatment. And this would also include the alternatives present, the benefits of such treatments, as well as the outcome. But a doctor is however entitled to withhold from the patient such information if such information will cause risk to the patient, and also in cases of necessity where it would be impossible to obtain such consent from that patient. And that was the principle held in a Montgomery and Lanarkshire Health Board. Now, let's go over to the rights of competent adults to refuse treatment with allogenic blood. Adult patients have the right to consent to or refuse treatment with allogenic blood. It's a principle. That principle is a principle of autonomy and self-determination. And that principle is enshrined in Articles 1, 3, 12, 18, and 19 of the Universal Declaration of Human Rights. And that protects an individual's right to dignity, to privacy, to liberty, to freedom of thoughts, conscience, religion, opinion, and expression. Those, if you look down, you also see that they are also contained in Articles 5, 8, 9, and 10 of the European Convention on Human Rights. And also these rights, as they are called fundamental rights, are also contained in the constitution of various states or countries. A patient's consent is paramount, and a medical practitioner is bound by the choice of an adult patient to refuse consent to medical treatment. No matter how weird it might seem, the medical practitioner is bound by an adult patient's decision on the form of treatment he would wish to undertake or refuse. That's contained in the case of Okonkwo and Medical and Dental Practitioners Tribunal. Now, this is where we need to give consent to. That is the use of bloodless medicine and surgery in the treatment of incompetent patients. And the first stuff we'll be discussing are minors. Now, who are minors? A child means every human being below the age of 18 years, unless under the applicable law to the child, majority is attained earlier. That's contained in Article 1 of the Convention on the Rights of the Child, 1989. What this means is, and it's almost in all countries, that the child is someone below the age of 18 years. However, countries may want to adjust the age to suit their culture or their held beliefs or so. And so that's why it says under the applicable law of the child in each country. Now, consent to medical treatment, in this case, bloodless medicine and surgery, is not solely determined by the age of a minor, but on the issue of sufficient understanding by the minor. And so we have what we call mature minors. These mature minors are eligible to consent to treatments, provided they can understand the nature and purpose of the proposed treatments and can communicate their decision. This was the holding of the courts in the case of Gillick and West Fork and Bisbeth Area Health Authority. In instances where these minors are limited by their age and they cannot give consent by virtue of their age, surrogate decision makers usually make these decisions for them regarding a form of treatment. However, these decisions taken by surrogate decision makers, whether they are parents, their guardians, or a court-appointed guardian, these decisions must be taken in the best interests of the child. And it's contained in Article 3, Sub 1 of the Convention on the Rights of the Child, 1989. Now, the courts, when they are called upon to resolve disputes between parents and healthcare providers as to a particular form of treatment that is in the best interests of a child, the role of the court is to assume the powers of the parents and either give consent or withhold consent regarding a particular form of treatment. Now, the court should do this or should exercise its role in its capacity independently and objectively. Now, in considering the best interest of a child, the question for the court is whether in the best interest of the child patient, a particular decision as to the medical treatment should be taken. The term best interests, funny enough, is used in its widest sense. And so it doesn't only mean what's in the medical best interest of the child. It takes into other considerations like the emotional, the social, and the psychological factors around those cases brought before the courts. However, the court must consider the nature of the medical treatment in question, what it involves, and its prospect of success, including the likely outcome for the patient of that treatment. Now, this test is not a mathematical one. It's, as we call it in law, you have an imaginary scale where you balance the evidence of both parties. And that's what the courts do. And they try to balance all conflicting considerations in each particular case with a view to determining where the final balance lies. And if you look at that case of NHS Foundation, King's College Hospital Foundation versus Harpstrop, that was the decision of the court. Each case is fact-specific. And it turns on the particular facts of the case. And because the law cannot envisage all factors that will need to be taken into account in working a patient's best interests, it makes the best interest tests an indeterminate test because it's flexible and the court can apply it in a wide range of considerations. And this has led to different court decisions, especially in the UK. Now, some of these cases are outlined there, and these cases involve decisions of the court whether to consent to life-sustaining treatment or to withhold such treatments from child patients. And so the court is called upon to determine if the hospital should withhold such treatment or should allow such treatment in the given circumstance. And the first case, the Manchester University and Benin, there the court held that it is the least bad option to allow life-sustaining treatment to be given to the child. In the next case, Pippa Knight, the court refused or withheld its consent to continue life-sustaining treatment for the child. The life-sustaining treatment was withdrawn and the child died after. And that was the holding of the court in Alderhay and Gard and Evans case. But there's something new in Rakib and Bath NHS Foundation. The court gave credence to the religious considerations of the parents, which is unheard of. And so the court said that in the absence of pain and suffering, that the treatment should be continued, taking into consideration the social and religious opinions of the parents. Now, due to this, there are other tests that have been proposed because of the indeterminate nature of the best interest test. Prominent among which is the significant harm test, which is to the effect that the state will only intervene once the child protection threshold is reached, in that the child will be seen to have suffered harm or is likely to suffer harm. Now, there are alternate forms of dispute resolution between parents and healthcare providers. And this includes mediation, arbitration for moderate level disagreements. In other jurisdictions, though, disputes involving parents and healthcare providers may not be prominent because the legal system either tilts toward the opinion of parents or healthcare providers. Now, what this means is that, for example, in Nigeria, the legal system tilts towards healthcare providers, and healthcare providers can go to court to seek orders on their own to transfuse blood to a child patient. We move over to mentally incapacitated patients. Article 3 of the Convention on the Rights of Persons with Disabilities guarantees the right of mentally challenged patients to dignity, individual autonomy, including the freedom to decide what to do with their own bodies. That is the issue of informed consent. Now, this right to informed consent has received both statutory and judicial substratum. You see Section 26 of the Mental Health Act of Nigeria, Section 1 sub 5 of the Mental Capacity Act of England, and the cases of Remeda Yeta and Risi. Now, where a mentally challenged patient is unable to give consent, decision makers or donors of a lasting power of attorney are called upon to give consent on behalf of the patient, again, in his best interest. Now, that is the same whether the person is caring as a family or a relative or a guardian appointed by the court or a healthcare professional. Now, in trying to break down the considerations, section for what amounts to best interest in the case of mentally challenged patients, Section 4(6) of the Mental Capacity Act of England outlines the various considerations in reaching a best interest decision on behalf of a mentally incapacitated patient. And they are the person's past and present wishes and feelings, the person's beliefs and values, which include his religious, moral, or cultural, or political beliefs and his values that will likely influence his decision if he has capacity, other factors that he will be likely to consider if he were able to do so. However, the problem of the best interest test still persists despite the above laid considerations. And this issue of best interest keeps coming up on and on. And there are still various different decisions. For example, if you look at the case of LL.B versus Brighton and Hope City Council and Aintree University Hospital and Trust, we get these divergent decisions. Now, where patients have an advanced decision to refuse treatment, their decision should be respected, even if others think their decision to refuse treatment is not in their best interest. Finally, we looked at patients in emergency situations. An exception to the doctrine of informed consent arises when a patient is unconscious and there exists genuine emergency. The impracticability of conferring with and obtaining the consent of the patient dispenses the need for obtaining informed consent. Now, surrogate decision makers are also called upon to make decisions, and they must do so in the best interests of the patient. If a patient is in the possession of a duly executed advice directive, it is the duty of the doctor to act in accordance with the directive. And that case of Mallet and Schumann is very instructive because the doctor did not respect the advance directive. He went ahead to treat the Jehovah's Witness patient with blood, and he was held in negligence, and he had to pay damages for his conduct. Now, in conclusion, the use of bloodless medicine and surgery as a form of treatment is not in itself evidence of negligence. Consent must be sought and obtained before undertaking bloodless medicine and surgery treatments. Adult patients have the right to refuse treatment with allogenic blood. Decisions regarding choice of treatment on behalf of incompetent minors, mentally incapacitated patients, and patients in emergency situations must be taken in their best interest. The indeterminate nature of the best interest test has led to controversy and different court decisions. Thank you.
Thank you very much. At this time, I think we're able to do question and answer for the three speakers. There are some questions posted in the chat, and then others can raise their hands and try to get recognized. I think I'm looking at one question for Barrister Ediru. What is your opinion on not getting a medical guardianship and having two physicians document the need for blood transfusion?
Okay, let me see. I'm trying to get that question. getting medical guardianship and having two physicians document the need for blood transfusion. Oh, it depends. Like if the patient can make his consent before the procedure. Now, unless there's dispute between the guardian or the parents, if the person is a minor or is incapacitated. Now, that's the only reason where, let's say you get a medical guardianship, a court will have to appoint that person. And having two physicians document the need for a blood transfusion, it's not the physician's choice, the physician's choice to document, even if there are two or three. In cases of dispute, the court will have to decide if, okay, the person said if he's a minor. Okay, I think I just saw that. Well, if it's a minor, then, and it's an unresolved dispute and it goes to court, it doesn't matter how many physicians thinks the blood transfusion is necessary. Now, you place the evidence before the courts, both expert evidence from the parents or the guardian, and then that of the medical team. It's left for the court to decide. So I don't think whether it's 2, 3 physicians, I don't think it's of no issue, it's of no importance. The court will decide that.
Hey. There's a follow-up question for how is the best interest determined in the case of minors?
Yes, like I said during the presentation, you have to, the court has to be objective in its decision. And the court has to take into cognizance these various considerations. Now, the court will have to take in the likelihood of success of the procedures, either blood transfusion or bloodless medicine, or the bloodless medicine option. The court will then determine the likelihood of the success of the treatment and the outcome of the treatment. Now, if the court is satisfied that it's in the best interest of the minor to go ahead with blood transfusion, it will make that order. But if the court is not satisfied, then bloodless medicine treatment can also be taken. It all depends on the decision of the court.
All depends on the courts. Okay. Thank you. We have a question from Daniela Nwoko, LL.B. Can you unmute yourself?
Good afternoon.
Oh, you're muted again.
Good afternoon, everyone. Can you hear me? Am I audible?
Very well, very well.
I don't have a question. I have some comments in support of Mr. Gaga's presentation and in response to certain questions here. If Mr. Gaga, with your kind permission, I can go ahead to make some comments. Is that all right?
Please do.
Okay, so like you have rightly mentioned, the best interest test is not a hard and fast rule. There's no hard and fast rule. It's not cast in stone. It's based on the facts presented before the court. While there's a principle that speculates what the best interest rule is, while there's a principle, it will still depend on the facts set before the court. The psychological variables, what are the alternatives to the prescribed treatment from the physician, be they 1, 2, or in their multiples? What are the alternatives? And then the advantage, the benefits weighed against the risk. Even when the parents are coming up with, when the reasons for the parents' objection to the blood transfusion is based on religion, if they can present to the courts medical evidence that proves that bloodless medicine still supersedes blood transfusion, that will tilt the balance in favor of the patient. If there are, just like the question I'm seeing here, if there's an alternative to blood transfusion and a particular physician is insisting on blood transfusion, if it is presented to the court that there's an available alternative physician willing and ready to subscribe to the preferred treatment of the patient, it is very likely that the court will tilt to giving the patient, be it a minor, the opportunity to seek a preferred treatment. Take, for example, certain individuals go to the hospital with an already preferred DND, will not resuscitate. Even if the physician feels that, oh, if I resuscitate this person, he has the ability to live 1,000 more years, that documentation already ties the hand of the physician from doing anything, even though it's in the best interest of the patient. So it is, as we have said, based on the facts set before the court. Unfortunately, in our judicial system in Nigeria, the court is already tilted in the side of the medical practitioners. And just as the Joanne mentioned in the beginning, we need to keep learning. The problem we have in our system is that our judges are ignorant of the advancement in medical health, especially with respect to bloodless medicine. And most of our medical practitioners are stuck in the age-old practice of blood transfusion. Some of them don't even want to bring that option to the knowledge of their patient. They just want to have the easy transfuse the blood and let us go on with it. The idea of presenting the option of alternative to blood transfusion is as a last resort for them. So patients are now encouraged to make their own research. Sometimes it is the patient who will bring it to the knowledge of the medical practitioner. Oh, what if I do this? What if I take this route? What if I take this option? And then you will see some of them reluctantly agree. And while others will be, oh, that is an option you can subscribe to. So seminars like these are things that can also help both the medical practitioners and our judicial system to grow. Thank you very much for the opportunity.
Thank you very much for that addition. It was succinct. It was really explained. Thank you. If I may just add this, it's time for our judicial system, especially in Nigeria, to wake up and to see to be objective in its decision. Yes, for a fact, doctors here do not know much about bloodless medicine and treatment. They've not even researched about it. People don't even know. The courts do not know. While it is good practice for them to refer to centers where these treatments can be done, but because of their ignorance, they don't know and they insist on blood transfusion. And they go to court using ex parte applications. They just go to seek an order without even hearing from the parents of the child, without presenting expert witness. They agree, the court makes decision to transfuse blood. And this is unacceptable, especially in the 21st century. So it's an ongoing battle, and we hope people will be educated and see the need for bloodless medicine as an advantageous and as a better form of treatment than blood transfusion.
All right. Thank you so much for the discussion. There are so many more things to talk about, and there are probably 4 more questions in the chat that we will have to have for written answers, I think. We need to conclude the session in order to keep the rest of the whole symposium on time. Thank you, all the speakers, so much. And